Hi, this is Ayush. Welcome to our presentation on the landmark case of Children Rent a Car and Cleaning 1978. This case is a pivotal decision in contract law, particularly in the realm of consumer protection and standard from contracts. Today we will take an in-depth look at the facts, legal principles, and implications of this case. We will explore how it highlights the tensions between freedom of contract and fairness, especially in transactions involving hurried agreement or fine print clauses. This presentation will cover the background of the case, the key legal issues, the court's ruling, and the rationale behind the judgment. We will also discuss how this case has So, we are on the second slide. In this case, we examine a dispute between Tilden Rent a Car and John Clendening, a frequent customer of Tilden. The primary question is whether Clendening is bound by terms in the rental agreement that he did not read or explicitly agree to. These terms voided coverage under a collision damage waiver if the driver consumed even minimal amount of alcohol. This case is significant because it challenges the long-standing principle in contract law that a signature alone is enough to bind someone to the terms of an agreement. Instead, it introduces the idea that unusual of onerous terms must be clearly communicated, especially
Hello, my name is Sonia. On the third slide of the presentation, the case we are analyzing is Tyndall Rent-A-Car Cooperative Lending, decided by the Ontario Court of Appeal in 1978. The parties involved are Tyndall Rent-A-Car, the plaintiff, and John Clendening, the defendant. Clendening, a frequent traveler and regular customer of Tilden, rented a car at Vancouver Airport. At the time of the rental, he opted to pay an additional fee for a collision damage waiver, which he believed would provide full non-deductible coverage for any damages of the vehicle. This understanding was based on prior explanation provided by Tilden's employer during previous transactions. The contract he signed included a clause on the reverse side in the fine print that voided the waiver if the driver consumed On the fourth slide, let's now delve deeper into the key events and procedural history of the case. After signing the rental agreement, Clendening drove the rented vehicle in Vancouver. He had consumed alcohol but was not intoxicated and had full control over the car. While attempting to avoid a collision with another vehicle, he hit a pole causing damage to the rented car. At trial, it was revealed that the collision damage repair which Clendening paid for included an exclusionary clause. This clause voided coverage if the driver consumed any alcohol, even if in minimal amounts. The clause was printed in fine type of the reverse side of contract, and Clendening had not read it. He relied on prior explanation from Tilden employees, which suggested the waiver provided full coverage unless the driver was intoxicated.
My name is Balnoor Singh and I am going to describe slide 5. The court faced several critical issues in this case, all of which revolve around the enforceability of the exclusionary clauses and the broader principle of contract law. First, the primary question was whether the exclusionary clauses in the rental agreement were enforceable given that they were not explicitly highlighted to Clendening and the clauses were buried in the fine print and contradict Clendening responsible understanding of waiver scope. Second, the court had to consider whether Tilden rent a Now I am going to describe slide 6. The Ontario Court of Appeal ruled in favor of Clendening, dismissing Tilden appeal. The court concluded that the Tilden could not enforce the exclusionary clauses in the rental agreement. The decision hinged on several key factors. First, the court emphasized that signature alone does not automatically bind a party to a contract terms, especially when those terms are unusual, onerous, or inconsistent with the agreement's overall purpose. In this case, the exclusionary clauses were hidden in fine print and directly contradict the waiver intended purpose of providing full damage coverage. Second,
Hello everyone, I am Jajbir Singh and I am going to discuss the slide 7. The court's reasoning focus on the lack of a true assent from Clendening. He signed the rental agreement believing it provided full non-deductible coverage consent with his past experience with Teldon and explanation provided by its employees. At no point was he made aware of the exclusionary clause voiding coverage for alcohol consumption. The Count observed that the hurried and informal nature of car rental transaction creates a context where customers cannot responsible for expected to read and understand every terms in a standard form contract. The reality undermines the idea that cleansing In slide 8, the court's decision was also formed by border policy considerations aimed at protecting consumers in standard form contracts. One key concern was the nature of exclusionary terms, which were both unusual and onerous. The clause voiding coverage for any alcohol consumption was inconsistent with the purpose of the waiver and went beyond what most consumer would reasonably expected. The court recognized that businesses often have superior bargaining power and knowledge, particularly in transactions involving.
Hi, my name is Tanvi Singh. Today I'm going to describe about slide 9. This case has been a profound impact on the contract law, particularly in the context of consumer protection. It different itself from the early case of least range, which has a data signature binds to signer to all terms in contract. The court in Tilden Cladding took a more consumer-friendly approach, emphasizes the business must provide a reasonable notice of unusual or unurious terms. The principles of reasonable notice established in this case ensure that hidden clauses in the standard form contracts cannot be enforced unless the business make a genuine effort to bring them the customer's attention. This ruling shifted to burden onto business, requiring them to prioritizing.
Hi, my name is Tarvir Singh. Today I am discuss about slide 10. To summarize the case of Taylor Rent-A-Car, Lending offers several keys takeaways. First, it challenges the notion that signature alone is sufficient to bind a party to contract. The court emphasized informed consent is critical, particularly when dealing with unusual terms. Second, the case underscores the importance of transparency in the standard from contracts. Business must take active steps to highlight hidden clauses and ensure that customers understand their implications. Failure to do so can render such clauses unenforceable. Third, the court's decision prioritizes and fairness and consumers' protection. It recognizes the imbalance of power.
Hi, my name is Arvind Singh. Now I am starting slide 11. Now that we have covered the case in detail, we would like to open the floor for any questions. To guide the discussion, here are some possible questions. First, how does this case influence modern consumer protection laws? Second, could Titan have avoided liability by clearly highlighting the exclusionary clauses? Third, what implication does the case have for standard form contracts in other industries such as insurance or telecommunications? We encourage you to share your thoughts and insights. Our goal is to deepen our understanding of how this case shapes the interaction between businesses and consumers in contract law. Let's begin with any questions you might have. Now I am starting slide 12. In conclusion, the case of Titan Rent a Car Co. v. Calendaring highlights the importance of fairness and transparency in contract law. The court's ruling protected consumers from being bound by hidden, onerous clauses in standard form contracts, setting a strong precedent for reasonable notice and mutual understanding. This case reinforces the idea that contracts should not be traps for the unwary. Businesses must take active steps to ensure that customers are aware of significant terms, especially when those terms deviate from the customer's reasonable expectations. By prioritizing fairness and informed consent, this decision has